Good morning, Crystal. How are you?
Good morning, Jevon. How are you? Did you have a good weekend?
I had a glorious weekend. Glorious weekend.
Ah,
Nothing happened.
nothing. Oh, no, I like those kind of weekends.
Nothing at all. Nothing happened.
I had a, we had rain, so therefore my garden got lots of rain. So that was
Nice.
cool. I didn't
Nice.
even have to go watering on Saturday, so that was pretty awesome.
Very good.
Yeah, so it was overall I played tennis for about 4 or 5 hours, so that was
Oh,
cool.
really?
hmm
Oh, good for you.
Yeah, I did. We had a successful parent meeting with our kids.
Oh, good. Good.
Yeah,
So you're ready.
I'm ready. We
You're all
have
rested?
we have 3 kids that have been accepted. One in college with scholarships to play tennis. One at Howard.
Great.
One at
Great.
Clark. She's there now.
Okay. Okay.
Um, then we have two that are either they're waiting for their offers, their confirmation offers for here in the state of California.
Awesome. Awesome. Awesome.
Yeah.
Well, um,
And
that's
one
great.
child going pro
Pro
tennis.
tennis. Really?
Yeah. And one going to
Wow.
Harvard. Now tell me we not doing some stuff with our youth
I'd
program.
say you most definitely are. You most definitely are. Well, I'd like to take this moment to welcome everyone to our show. Everyone, this is Conversations on the Patio. This is a show about things we should have been taught when we were in school. The way this show came about is Crystal and I met on LinkedIn, and we came to understand that there are a lot of folks out there that get information from their friends in a relaxed environment, but they don't always get the best information. So we wanted to create a forum where we could actually put some info out there, especially from a financial point of view, but not always, and give people the correct information. So I'm Jevon Thomas. I am a registered financial advisor, and joining me is my friend and colleague, uh, Crystal Mitchell. Her background is as follows, and I'm going to read it to you because it's very vast. She's a business coach and consultant. She's the CEO of Mitchell Business Solutions. She's the co director of Recycling Black Dollars. She's a co host of The Business Zone with Crystal and Gilbert. That's another weekly online radio show. That's all we're going to say about that. She's the instructor of Mount San Antonio Community College. She's a certified network for teaching entrepreneurship instructor, and she is a QuickBooks Pro Advisor financial strategist. So, welcome, Crystal.
And thank you. And I'm glad to be here and glad to be talking about the topics that we're going to talk about, the topic we're going to speak on today. But it's all about making sure our communities and our people and have all the necessary information to make the right decisions for themselves and their lives and to make sure that they're financially sound.
That's exactly right. That's exactly right. And we know that so many things that we talk about have a financial bent to them. So it's really good that you're on here with me, giving me the prompts that you do, and coming up with that really cool information through questions that some of us in this industry don't really think about. At now, though, we have a special guest. This is a gentleman by the name of Gary Mitchell. He is a friend of mine. He's an attorney here in Irvine, and he helps me, especially with wills and trust, the establishment of those, and how to work those and how they affect people. So I wanted to take advantage of bringing him on and letting him talk with us about how those are established, what they are, when do we need them, and all of that good stuff. So, are you okay with bringing Gary on?
I am. I'm looking forward to it because, with everything going on with the pandemic, there are a number of people that have found themselves in some really incredible spaces because they unexpectedly lost loved ones, and they weren't ready. And then I'm just always amazed at the number of celebrities that leave this planet without wills and trust, and I and I don't understand it. I really don't
Right.
understand it. So maybe Gary can help me put some clarity on that for me.
Yeah, he definitely can. He definitely can. Okay, so let's go ahead and bring him in, and we'll see what he has to say. Gary? Oh, here he comes.
Here he comes now.
Gary Million, how are you, sir?
He's getting his
I
audio.
think, are you
Afternoon.
on? Oh, there we are. How you doing?
I'm doing just fine.
Good
Hi,
deal.
Nice to be
Gary.
here. Hello,
Thank
Crystal.
you.
How are you?
I'm just great. I heard a little bit of the show, but figured I better get off my phone so I didn't get any nasty feedback or anything.
Because you never know these things. It's fantastic that we can work virtually, but does it always work for us? No, it does not.
There'll be a glitch here and there, but so far so good.
Yeah, yeah. Gary, we've been friends for quite some time, and I really appreciate your knowledge. But can you tell us a little bit about your background and some of the things that you do?
Well, I'm an estate planning attorney here in Orange County, and I also work for BTA Advisory Group as a compliance and uh, keep everybody on track legally. And I primarily do estate planning, including wills and trusts and other uh, plans that people may require to help them avoid probate, save on taxation, and just generally get their affairs in order.
That's awesome. And that's really what we want to talk about is wills and trusts because we find that there are a lot of folks out there who have heard of what a trust is. They've heard of what a will is. They don't know exactly when to apply them, and they don't know what the protections are. And there's some misnomers out there.
Oh,
Like, for
yes.
example, you don't have to pay taxes if you have a trust. So we want to dispel some of those wrong questions or issues and get down to it. So, if you don't mind, can you tell us what exactly is a will and how does that differ from a trust?
Okay. Well, a will is a document that you sign with witnesses indicating how you want your estate, which is your property, your assets, your stamp collection, your investment accounts, anything you've got is part of your estate,
Hmm.
and how you want those assets to be distributed once you leave this world. Because I've heard you can't take it with you. So you would rather be able to designate who gets your stuff rather than have the court do it arbitrarily. And one way to do it is with a will.
Okay.
And there's some advantages to a will. It's relatively easy. You've heard stories about people, writing a will down in the back of a napkin, and the
Right.
courts will, subject to somebody contesting it, that will be what the probate courts accept.
So, do you have to have any language there? Do you have to say something
No,
particular? Do you have to turn it in to
I
someone?
mean, the more you have, the better.
Hmm.
The more likely the court will accept it, the more official it is, the more specific it is, stating that you're of sound mind, you're not being subject to undue influence or arm twisting or anything else, that nobody's got a gun to your head, so they're stealing your estate.
Hmm.
And that's where it helps to have witnesses. Usually in California, having two witnesses is a benefit. And
Okay.
also, people will use their wills to make guardianship provisions for their minor children. Here again, you would rather choose who will take care of your kids than have the court do it.
Hmm. Okay.
But if your estate in California is over $150,000, even if you have a will, your estate will be subject to probate, which is a court proceeding where a person is designated as your personal representative who will work with the court to make sure your will is probated in the way that you specify.
So let me make sure I understand this. If you have a few belongings and you want to disperse them in a particular way, you can write down on a piece of paper or type up a piece of paper that says, I'm in sound mind. I want so and so to have X amount of dollars or my um, collection of beetles or whatever it is. But and you can do that to avoid probate, and that those
Well,
items will
that,
go
that will
directly to
not
that
avoid
person.
that will put you into probate. That does
That
not avoid probate.
that will put you that won't save you from probate.
Correct.
Okay, so how do
That
I
in
get?
itself will not. That's why you hear the expression, we're having, my mother's will probated. It's
Okay,
going through the probate process through Superior Court. Well,
okay,
through
so how do
probate.
I get out of probate?
Well, here again, if your estate is worth less than 150,000,
Hmm.
and that does not include any life insurance proceeds or retirement account uh, distributions, because those have a designated beneficiary, and those automatically pass the time of death. So
Right.
those are outside of probate.
Okay.
So let's say you have, a $300,000 home and a $200,000 investment account, just not a retirement account. Well,
Right.
your probated estate would be worth 500,000.
Okay.
And fees on that, a probate can take a year to 3 to 5 years. I've seen some just go seemingly on forever because there are so many issues that can crop up depending on, you know, family disputes, title disputes. There's all kinds of things that cause a probate to last longer.
Okay.
And it can cost, there are standard fees established by the state, the probate fees for the probate attorney and for the personal administrator. So this can be thousands of dollars, and it's graduated based on the value of the estate. Now, the best way to avoid probate for a small estate is to have a living trust put into place. Now,
Okay.
trust does some of the same things a will does. It designates who you want your belongings to go to. It says who will be your trustee,
Hmm.
but it is not subject to probate. It is not public record. It does not uh, have to be filed anywhere. Where a will to for a will to be administered, it has to be filed with the courts.
Okay, so that's why we have bunches of wills out there
Mhm.
for some folks because they never filed one with a
They
court
didn't
as a
have a living
document.
trust.
Okay.
And another thing recently changed is the California Medi-Cal recovery. Uh, Prior to January of 2017, the courts uh, could recover Medicare expenses that were paid after a person turned 55. They could be reimbursed up to the amount of assets that individual had.
Hmm.
Now, if they changed to where it is now only probated assets. So if you and your spouse have a trust put together and you owe a lot of money for past Medicare expenses, those will not become recoverable due to their part of your non-probated estate made possible by your living trust.
Interesting.
So
Interesting.
it's a good idea to have both of those in place, a will and a trust.
Typically, if you have a living trust, you have what's called a pour over will, which basically states that any asset that is not initially officially titled in the trust pours over into the trust by means of the will.
Hmm. So now, I if you don't have a whole lot of money, is there anything wrong with probate? I hear people saying probate, and they have horrible
Well,
things to say.
it's a hassle for your beneficiaries, your heirs, to go through, and it's
Hmm.
expensive.
Hmm.
It can be, like I say, several $1,000s for a relatively small estate.
Hmm.
If you have real estate, then that almost automatically puts you in a probated position in California uh, with the property values that we see. And even if you have a $1 million house with $1.5 million mortgage, the courts look at that as $1 million asset on your uh, you know balance sheet.
Mm.
So the courts would then decide where the assets of the house go, or if the house has to be sold, or what have you.
Right. And if there is a will in place, it'll still be probated. If there's no will in place, then the courts will look to whoever is nominated as the personal administrator to see whatever claims there are against the estate, and then uh, settle the estate per intestate succession, which was it's a long list of what the court follows if there are uh, no will in place. It'd be your kids, your grandkids, your brothers, your sisters,
Mhm.
your aunts and uncles, your second cousins, your third cousins, on down the list until they find a relative or in that intestate succession uh, schedule who can take your assets. And if nobody's there, that can, it goes to the state.
Oh, wow.
So is
Our
there,
tax dollars at work.
yeah,
Yes.
tax dollars at work. Is there a particular time that a person, so first of all, first question is, so it doesn't matter if you're cash poor, but if you own property, you definitely should have a trust or something in place to protect that and for your heirs. And
Yes.
then the second question, is there a particular, let's say I'm a young couple, if I was a young couple, do I do something at that time? Do I wait till I'm in my middle ages, my working world, or is there any particular time a person should say, hey, I need to talk to an attorney on how this happens?
Kind of depends on the situation. Like a young married couple, especially if they buy a house, that's a good idea to look into it. Uh, Basically, when you have a living trust, the trust owns everything that you have, but you own the trust. So your level of control remains the same. You make all the decisions you would normally make. Everything stays the same. It's just there's that uh, step in between, that kind of buffer that the trust handles things. For example, when you buy a new piece of property, you would purchase the home as, Jevon Thomas, trustee of the Jevon Thomas Living Trust, dated, you know, February 1st, 2021.
Okay.
So I
Okay.
would own the property, but the
You would own
trust
the
would.
property, but the trust technically owns it. You own the trust, though.
I see.
So a lot of people will do this when they buy their first property, because that's what propels them into the world of being subject to probate. A lot of times people do it when they have their start having children, because they want to make sure their children are taken care of, with the idea that their estate will grow. And even though they may not have a huge sum starting out, over time it'll build, and they want to make sure that their children are taken care of and the people they want to raise their kids are in place. And then they can
Mm.
choose someone who's a great caregiver to have custody of the children, but that person may not be good financially, and they'll want someone else who's a financial genius to handle the kids' financial affairs, and
Mm.
that's certainly okay.
Mm.
Another thing people do at the time they put their kind of get their affairs in order, along with the living trust and the will, they'll do a durable powers of attorney. So if they become incapacitated for whatever reason, there's someone in place who can make financial decisions for them that hopefully they've discussed with previously, so they know they have they know how they want their affairs handled. And then if that person becomes, out of the coma or out of the hospital and is able to act on their own again, then they take over their affairs once again. And then there's the Advanced Healthcare Directive that not only specifies how the person wants to handle, do they want to be resuscitated? Do they want life-saving measures taken, or do they want to exercise their right to die? But it also appoints the individuals who will help them, will make the medical decisions for them should they be incapacitated.
Mm.
Mm.
I see.
Yeah, I was the durable power attorney for my mom and my
Mhm.
uncle, and as well as the directive, as they both had one had COPD and one had cancer. So
Oh,
toward when they were no longer able to fight for them and advocate for themselves, then we
sure.
put those documents in place.
Mm.
And those are the
Uh,
kind of thing that a complete estate plan encompasses. Another is the uh, medical authorization document that allows a designated group of people to receive medical information should you be incapacitated. It's the HIPAA authorization the Health Insurance Portability and Accountability Act.
I see. So
Because
I
it,
know you're not an attorney. Not an attorney. I know you're not you're an attorney, but not a tax person.
yes,
So on that line, can someone come to your office and you can explain all of that to them and help them with that documentation? Do you fulfill that role?
yes, as far within the confines of the estate plan. If they have advanced taxation issues, it's better to, and I always recommend people work with a CPA or their tax provider in conjunction with the estate planning attorney to make sure that their plan works well together from a tax standpoint as well as a just general planning
Sure.
standpoint.
Yeah.
Now there are some things that the trust helps with for estate planning. Now, with the the $10+ million federal income tax exemption for estates, a lot of people don't need the advanced estate plan techniques, family limited partnerships, uh, things like that to avoid estate tax because the threshold's so high.
Mm.
But there are some advantages to a living trust in terms of some capital gains uh, tax that can be saved due to a double step up in basis when it's a married couple. So
Hmm.
there's things like that that are worth looking into in addition to just saving the probate.
Okay. Now, correct me if I'm wrong, but if you have a will with an X amount of dollars worth of property, if that goes to your children,
Mhm.
uh, I've heard horror stories of people inheriting things and then having to pay tax on that. So, can a trust avoid those issues, or do you get hit with problems?
Well, it depends on the situation. Like I say, it's always best to consult with your tax advisor.
Mhm.
But inheritance in California, well, in the United States now, if it's a married couple, is around $22 million that they can pass to their children without estate tax. So, and a lot of people
Okay.
like to set up kind of a higher, a tiered payout for their children. So their 18-year-old son's not given $10 million and goes out and blows it on the new Ferraris and wine, women, and song.
Sounds
So
like a
some
fun
people
guy.
set up, yeah, a lot of people have it paid out at different ages, or different life events. The trustee can pay X amount for college expenses, another chunk for buying their first home, getting married, or if one child becomes the next Bill Gates and the other child has some special needs, the family may choose to funnel more funds to that child that needs it versus the child that,
Sure.
well taken care of already.
So this is all about control, right? From the parent's point of view, from the person who is in the grave. So you, as the person that is holding the money, you can control what happens to it after the grave. And if you don't
Yes.
want to do that, if you like the idea of your children scrambling and fighting for what have you, then don't do that and let them go through that pain, I
Yeah.
suppose.
Or you can give your funds to a charity, or there's any number of things you can do with your assets.
Or maybe even Crystal.
Or
Ah.
crypto. Yeah.
So, do you
But
have some? Go
I
ahead,
think I
Crystal.
mentioned this to Jevon. It amazes me that how wealthy are there are quite a few wealthy people that have passed on that did not put anything a trust in place. They may have had a will, maybe not, but that's always I've always marveled at that because I assume they have a team of individuals, CPAs and lawyers that are working for them. And what how does that get missed?
Yeah, you hear a lot of different horror stories like that. Then the other, I guess last year, a relatively well-known celebrity died, and everybody was shocked that they only had like $1.5 million in their estate, because that's what showed up on some portion of it that did need to go through probate for whatever reason.
Mm,
What they didn't know is how much passed in other ways that the probate court never was made privy to. So that person could have had a $30 million estate, but only that small chunk went to probate. So that's what was publicized. So we
I
never
see.
really know for
Ah,
sure because a lot of it can remain completely shielded from the public.
Oh, okay. Well, then now that makes sense.
yeah, that makes a lot of sense.
It just makes no sense for them not to, when they have so much that they have to protect, not to have. But so it may be a portion of it wasn't in.
Right. Although you still hear cases where, multi-million dollar estates do go through probate, and somebody somewhere was either stubborn and didn't want to follow financial advice or had bad advice, or who knows what goes on sometimes.
Mm,
Hmm.
okay. Well, that
So,
answers some of my questions.
oh, good. Well, I hear situations, I don't think I've asked this before, where people will contest a will. They'll say,
Oh yes.
well, we say that he wasn't in strong mind, or I'm the brother of the sister, I should get something. Um, how, why is this not cut and dried? How do you, why does someone have the ability to contest once they've heard a court say this is the deal?
Well, in our litigious society, of course, people can sue for anything. But
Hmm.
what you see is some wills go back, 30, 40 years, or trusts even go back that far. There's been a lot of family dynamics that have changed in the meantime. Um, and the person may have made a last minute change, and it might have been their caregiver who kind of slipped, some documents and looked like they signed. So people
Hmm.
will challenge whether that person was in their right mind at the time new documents were signed. You hear about the 95-year-old man with the new 19-year-old wife. And
Mm.
you kind of wonder sometimes,
Yeah.
but and they may have been in there with a perfect right mind and without any influence. But the courts will look at evidence to show what may or may not have really been going on. A notary public may be a witness, other relatives. There may be doctors' reports showing they were in their advanced stages of Alzheimer's, so they couldn't have been in the right mind at that date. So the courts will look at a variety of factors to determine if that person really meant to do what is now showing up in the documents.
Okay. Well, now
And
let's suppose I'm a oh, I'm sorry to interrupt you. Were you gonna
it's
keep
always a
going?
good idea if you really do want to specifically disinherit somebody, you put it in the document and say, I hereby acknowledge I have this daughter, but I specifically am disinheriting her from taking any uh, funds from my estate. And
Mm.
that way they can't say, well, they just forgot about me.
So now, what if I'm on the receiving end of
Mm-hmm.
that property or that money or those assets? What should I do as a person to make sure that that's not going to have issues?
Well, if it's before the person dies or becomes of unsound mind, you would encourage them to get their affairs in order. A lot of times, children, even grandchildren, will pay for their parents, grandparents to get their trust put together. Because a lot of people, especially older folks who kind of still have that depression mentality, don't want to spend anything that they're not receiving the benefit of. So once they get their plan in place, that helps protect the beneficiaries. If it's after they die and things are kind of in a flux, then you would find out ways that you could show evidence that they were in fact in their right mind. This was what they intended to do. Other documents, a previous will. I mean, anything that the court could review to see that yes, you are the rightful heir and this is what should happen.
Hmm.
You would want to make available.
And
It's a bit of a morbid question, I
Mm.
think, but there are so many people that I know being in financial services and privately, I think because the economics of today's situation are pretty tough,
Yeah.
so there are a lot of folks out there that are actually, you know, really happy with the fact that they're going to inherit something, and they want to make sure that there aren't any hiccups in that situation. And honestly, they want to make sure that their parents or their grandparents' wills are or desires are fulfilled, so that whatever that person wanted, that actually happens. So protecting them with paying for the estate planning, that's one thing they can do.
Hmm.
Um, is there anything else they could do to make sure that those things they want their parents to do or their parents want to do rather is protected?
Well, keep aware of what is happening. If there's any changes in their health, or if the family changes, you often see siblings fighting each other, and one will be named as the trustee by the parent or whoever, and then that person then uses that power to cut out the rest of the family. So you you just kind of want to make sure that the person who had set things up is getting what they originally set out to get.
Okay.
Uh, in other words, if one of the siblings is running afoul of the truster's intent, they'd want to make that person aware of it and say, "Hey, Jimmy over here is trying to rip me off. Help!" And it
What
happens all the time.
I'm sure
Oh,
it does.
okay.
What are the normal, say, the costs, just kind of the customary, the big minimum of costs that to set up their wills and their trusts, or establish their wishes.
Well, depending on the amount of assets and but for a typical married couple with
Hmm.
one California property, I charge 1,600, and then anybody referred to by Jevon gets a 20% discount. But that's
Yay.
subject to that's kind of a general
Right.
uh, ballpark. Of course, a single person will be less because there's obviously less to do.
Hmm.
If they've got a number of properties, there may be more transferring that needs to be done, so the cost would go up. When people get over the that exempt threshold of, so like 11 million per individual, so 22 million for a married couple, then they can start looking at more advanced planning techniques. Like I said, there's charitable strategies that are in place. There's family limited partnerships, limited liability companies. There's a number of things that can be looked at if the circumstances are there.
Oh, okay. And I assume that also because family dynamics and people dynamics change on a regular basis, how often should they come back to revisit if that trust or that will needs to be revised? So, should they put a tickler on their calendar to come back and see Gary?
Uh,
How often?
I recommend at least every 10 years, unless there's
Okay.
been a major shakeup in the family that they are very well aware of. Or if there's some major change in the law, like if the new administration decides to knock the estate tax exemption down to, say, 3 million instead of the 11, then
Hmm.
people may want to kind of look things over and see if that's going to affect them or not.
Mm.
Uh,
People
typically,
as in the folks that are receiving or people are the folks that are giving?
well, both.
Okay.
Now, typically, language in a trust is designed to account for children who are born or adopted after the documents are signed. So you don't necessarily have to go back and make sure that the new children are there, but it's a good idea. But usually they will be picked up by the language in the document to include them.
Oh, because
Mm.
you have a blanket, are my children, and that could cover existing children and future potential
Yeah, it
children.
specifically mentions after born or after adopted children.
Oh, okay, okay. And then if you become grandparents, after your children are grown, then I assume you definitely need to make some adjustments when your married children or your children get married and change lifestyles.
Some people do, some don't, depending on the family needs. A lot of people say that I'm going to let the kids worry about their kids. Others will specifically provide the college expenses, things like that. and it's really up to the individual how they want to set those up.
So, are there any particular terms that someone should know about or watch out for if they have a will or a trust? Is there something that could mean one thing? It looks like it means something, but actually means something else. Have you run into that?
Well, there's a lot of different, starting out, the person who sets up the trust can be the trustor, the settlor, or the grantor. And those are all basically synonymous. So the documents say that they're the trustor, but somebody else may refer to them as the settlor, same thing. Trustee is always the same. The trustee of the trust is the trustee. There can be co-trustees, and successor trustees. Typically with the living trust, the person who's the trustor is also the initial trustee, because the trustee is the one who has control over the assets. So the successor trustee only comes into place when the trustor is either incapacitated or passes on.
Mm, okay. Now
Uh,
you mentioned you keep saying the word living trust. Is there a different kind of trust that we should be aware of?
well, that's kind of the more of a trade name, not trade name, but it's a generic name for a revocable trust. Just because it's living, because it can be changed at any time. What people need to realize, if you have a trust and it's revocable and states that you can change it at any time,
Hmm.
that gives you a certain degree of freedom, knowing that whatever decisions you make now, you can change down the road, or you can tear it up completely and start over. A
Mm,
lot of people are hesitant to get their estate plan put together because they don't know who they should name as the trustee or who should have the power of attorney for assets for them. But I say go ahead and put somebody in just so it's covered. And down the road, if you want to change it, you can make it an amendment. You can easily change. You don't have to get hung up on having it perfect to start. You can
mm.
you can always modify it. The
You
other
know,
type of trust is a irrevocable trust, which can't be changed. Now, there may be certain limited changes you can make, but inherently the trust is irrevocable. And that's primarily done when you're taking tax benefits that are kind of locked in. And if you want to make sure that your child is getting or your beneficiary is getting these funds, this trust cannot be revoked if you get remarried or what have you. But it's primarily to lock in some of the tax benefits that you've taken over the
mm,
course of the trust.
okay. Crystal, did you have a question? I think I might have cut you off.
Oh, no, 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 no. That I was actually getting ready to ask about the irrevocable. Boy, I knew the two different terminologies, and so I
Uh,
wanted to, be clear on what the differences were.
okay. You know, in my line of work as a financial advisor, I set up retirement plans for small and medium and large companies. Um, Undoubtedly I run into a couple issues, and one would be, the buy sell agreement and key man insurance. But another one is that whole common property thing here in California. So um, and I hear that term bantered around a bit. So when it comes to common property, number one, can you tell us what that means here in California with regard to married couples and businesses? And then, um, when it comes to estate planning, how does that play into the mix? And can you use a will or a trust to satisfy some of those issues?
Sure. And just as an aside, the life insurance trust is one of the most common irrevocable trusts that you see. Although with the high level set for the estate exemption, we don't do as many life insurance trusts as we used to back
Hmm.
in the day when it was $1 million exemption, for example. But community property is how property's held in 11 states, including California. I think it's still 11. And what that means is a married couple, what they earn or what they commingle, any funds or assets is owned by both of them in common. So each owns 100% of the property that it, how should I say this? Whereas a separate property state, the husband and wife may just own 50% of the property, and it's, uh, it's handled differently in a variety of ways. In California, if um, your wages, all your income is deemed community property immediately upon acceptance. If you have what isn't commingle, isn't considered community inheritance, like lottery winnings, anything that you earn completely separate from your marital union can be maintained as separate property until you commingle it by putting it in the same bank account, pay for the house with your own home with separate property, separate funds. Then it becomes part of the community property pool.
Okay, so if we're regular people, we might just want to suggest that here in California, it doesn't matter who earned what to buy what money for what and how much money they got. If you're married and you did that during the marriage, then the spouse owns 100% of whatever it was that the other spouse generated and
Mm-hmm.
vice versa.
Yeah,
So you're pretty much sharing all of your property, not just 50% of it, but all of it with
right.
that person.
Yeah.
Okay, so now can you write a will to uh, not have them own that and
You
maybe
can,
turn that over to your business partner?
if both parties agree, you can change how the property is held. Sure.
Okay. So in today's life where we have lots of what do we commingled and strange families, or
Yeah.
families that are thrown together in lots of situations. I can't remember the name for that right now, but those special kinds of families. um,
Extended.
Extended, maybe that's the word. Um, in those situations, a person may say, okay, I own this business. I need this business to go to these particular children. And if the wife agrees to that, we need to put that in the will or the trust document.
Sure. Yeah,
Okay, and
you
then
can.
we
Yeah,
can, okay, and then
the
we don't have to worry about the community property thing.
yeah, the default's community property, but you can do a transmutation agreement, basically changing a certain amount of community property to your separate property.
Okay.
But
Now
both
let me
spouses
ask
have
this
to agree to it.
question. I'm sorry. So let's say you have business partners and you actually own a company together. How does that fit in with the community property? Because the spouse and the families and so does that have to be incorporated in that as well? If you
Well, the spouse in the community property state would automatically own their share of their spouse's interest.
okay.
So that's why you write key man insurance and
Mhm.
uh, the other business insurance that we write that I can't think of right now, so that your partner isn't, so that your partner automatically buys you out, so that you're not in partnership with your partner's spouse who may not know how to run the business.
Right.
So
Yeah.
that's something to discuss before you do either one of those, I would
Yes, for sure.
suspect. Yeah.
Yeah, I had a partnership years and years ago, and one of my partners had a crazy spouse. And we had to make sure we went back into our partnership agreement to be very specific that we did not want the crazy spouse to be, if something were to happen to her, to be, to absorb her share because we didn't want to deal with that crazy spouse.
Mm.
Yeah,
Crazy is a technical term, right, Crystal?
Yeah, it is.
yeah.
I don't know. Gary may have a different legal term for it, but in my partnership, it was a crazy spouse.
Well, a good example of that is the Los Angeles Rams.
Oh,
Okay.
When, gosh, I'm having trouble remember the name, but uh,
it was the wife, wasn't it?
yeah,
That
it was the wife who took over the team, and things got a little crazy.
yeah.
Mm.
Yeah, see, that's a legal term, technical term, crazy.
Crazy.
I haven't thought about that for years, but yeah, that's a good example of what happens when
And I don't think people really think about that when they're, you're all excited about your business, right? And you're not thinking that this person on the other side could have some major bearing on you. You go to the office parties going, "Woo, crazy wife."
Yeah. Carol Rosenblum, I think, and
Yes,
his
I think.
wife Georgia.
Yeah, so you have to really think about that from a business standpoint as well.
Yes,
It's not just your partner, it's everything that is involved around that partner, and especially if they're married.
yes. There's a lot of overlap with the estate plan and the business plan that should definitely be dovetailed to make sure that there aren't some crevices to, to fall into that kind of throw a wrench into the works.
Cool. Well,
Yeah.
Gary, one of our favorite parts of the show, and we've only got a few more minutes here, is "Don't Be That Guy." So that's a show where we talk about someone that's done something or hasn't done something that generally either they or everyone else around them is gonna not find good. So, do you have a "Don't Be That Guy" story for us?
Well, the the best one is don't be that guy who subjects your beneficiaries to probate for sure.
Hmm.
I did have a person who was had some health issues. He was living with sharing a house with a gentleman, and he told him that he was so helpful. He wanted him to have the house
Mm.
if he should pass away.
Hmm.
And the person was doing a lot of improvements, doing a lot of things, and and he kept telling me, let's get this put into place. And he finally agreed to do a trust. Went into the hospital, went into a coma, could
Mm.
not sign, and created a very messy probate situation. They ultimately found what purported to be a will, but it was more of a if something should happen to me and I can't make decisions.
Mm.
And then some unbeknownst children came out of the woodwork. A charity appeared
Wow.
that was mentioned. So there were a number of things that definitely didn't go the way that he intended. So
Yeah, there's a lot of those don't be. I think my sister's a realtor and she had a don't be this guy, and a young lady, her one of the client actually um had bought property with not a spouse, but bought property with an individual. Um didn't really have any major documents in place other than the purchase of the house, right? The property that they had left a whole lot of open gappy areas, as
yeah.
Gary called. And so the guy actually went and got refied the property, signed all the documents. She had no idea that it had taken place. Then he died.
Mm-hmm.
And so now, of course, she absorbed the loan that and ultimately lost the property. It was in losing the property because she had no idea that all that was taking place while he didn't say anything to her, and it didn't wasn't disclosed until after his death.
Yeah, you don't want to get the liability if you don't get the assets to go with it.
Right, exactly. Yeah. So definitely need to. So with that, the moral is to make sure you are sitting down with an estate planner to understand all the ins and outs from a legal standpoint.
Well, you're bringing up an excellent point I hadn't really considered. If you're in a partnership with a person, then no matter what kind of partnership that is, be it the marriage partnership, the business partnership, the co whatever other kind of assets people have, it's a good idea to kind of know about their estate plan, right? I
Yeah.
mean, if you can, if you own a business with someone, it's a good idea to know, hey, do you have that estate plan in place, just in case one of us passes away? We want to make sure that the other one's family is protected and also that our family is protected. and that the other person is protected. And that's tough to do if you
Yeah,
don't
and you
have
would
an
like to have
estate
a
plan.
yeah a business succession plan. So if something does happen, how's the business going to carry on, or will it shut down? You know,
Mm.
what's the desired outcome?
Mhm.
Yeah, that makes a lot of sense. And I suppose, looking at this from the point of view, blended family, that's the word I was trying to say. If you have a blended family, making sure there's a plan and that you understand the plan. And Crystal's very knowledgeable about my expression of get a plan. There has to be a plan.
Yeah.
So you should get a plan. If you're planning to do the inheriting, for whatever reason you're the one that's running the corporation or running the charity or whatever it is, if you plan to get an inheritance, then you really want to make sure that estate plan is in place, and that the will, if that needs to happen, that that's in place, and that they're not conflicting with each other.
Well,
Yeah.
and the blended family does create an issue because it doesn't always work out. It's not always the Brady Bunch. There's can be a lot of problems. What
Mm,
if the husband has one child and the wife comes into the marriage with five?
Right. It's
Do
true.
mm,
they
True.
split 50-50 with his kids and hers? Or does each child get a sixth of the estate? I mean, those are some in
And
the
I
one
would think
thousand.
those conversations should be had before we sign on the dotted line. If
Oh,
we're
exactly.
oh yeah.
Yep.
Mm, yeah.
we should be meeting with our estate planner before we even get married to make sure we understand what all of the what we're dealing with. Because
And what if the parent with the one child has the bulk of the estate, and the one with the five comes in with the shirt on their back? Is it fair that those five kids get the bulk of the other's estate, and the other that child's going to be going, wait a minute, this isn't what I bargained for? And you see a
Mhm.
lot of disputes like that, and there's no easy answer.
Mm.
Yeah.
So Crystal, you made an excellent point. Gary, you suggesting that people go to an estate planner or an attorney before they get married, just to hash that out and then put the plan in place, or should they actually wait till they get married? And what do you think? Who wants to? I mean, I'm sure it's happened that folks have passed away within a year of getting
Oh, sure.
married.
It's a good idea either to talk to a family law attorney or an estate planning attorney and say this is what we're coming in with. What How should we approach this?
I think especially if there's a blended family and maybe the children of a certain age, uh, their father is still out there. I think it's a real good idea because those are catastrophes waiting to happen.
Oh
And they
yeah,
do.
and they do. Yeah.
And they do happen. So before we close up, Gary, what would if a person was looking for a financial, an estate planner, what should they be looking for when they're selecting that person that's going to represent them? And I would hope that it would be for on long term, over the duration, especially if they're young and just starting out. What would be some of the characteristics or
Well,
things that you should be looking for?
you want to make sure they have a good background, good education, good uh, rapport with them. You don't necessarily want to pick the most expensive. You don't want to necessarily pick the cheapest. I get a lot of clients who messed up their legal Zoom, that kind of thing. So it's not the best thing to do. Do it yourself. It's good to have. And I've had clients say that my prices were not that far away from what they ended up paying when they got nickel and dimed by some of the online services. So there's that. Um, a lot of people go to the large law firms and find that the paralegals doing all their their work for them, and they maybe see the attorney once. Uh, I think it's good to have an attorney that is hands-on and does all the preparation themselves. But that's a matter of choice.
Hmm. Okay.
Well, go ahead, Crystal. I was
No,
gonna.
no, that I was in agreement with him.
Okay. So, Gary, two things. One, we have, as you can tell, different patios on our our backgrounds here, and we usually ask folks to judge which one they like the best. So,
Oh,
one,
yeah.
we'd like you to plug in that, and two, if a person has an issue and they want to talk with an attorney or they want to, can you give us how they could contact you? And of course, people can reach you through my website and Crystal's website and
Okay, well, I
Facebook.
do offer free consultations. I'd be happy to speak to someone. Usually we start out with a questionnaire so I can have an idea of where they're coming from. So when we do have that consultation, we can kind of get right to the main points.
Mhm.
And they can call me. I'm at 949-244-0102. And it's
Okay.
Gary Million, just like the number.
Well, that was purposeful. That was an excellent job, parent your last name and going into estate planning.
How
Now,
about that?
what was the phone number again? 949
244-0102.
Great, great.
0102. Easy number to remember. So
Very nice.
anyone out there with estate planning needs, and as you can tell, even things that you haven't thought about are some of the things that will crop up. So it's always good idea to sit down, and he has a free consultation just to find out where you are so that you don't get caught unaware. And it's so interesting with so many people that obviously have lost loved ones during this pandemic, and I'm sure nobody was ready for what has come of this. And there's some disastrous stuff that's going to come out on the other side of this
Yes.
because we were not ready or we were not prepared for this. So don't know how you get prepared for a pandemic, but you have to realize that your financial wellness and well-being is all part of any kind of crisis that's going to take place.
All right, that's excellent. So, I don't have any more questions for you, Gary, unless you wanted to pop one out, or Crystal, if you had one.
I'm good. It was
Okay,
excellent, Gary. You were very informative.
Well, thank you. I
Well,
appreciate the opportunity.
great. Well, now we reserve the right to call you back, just in case we come
Well, I'll
up with
reserve the
another
right to come
topic.
back.
I
Good
like
deal.
that.
Good deal. Well, all righty. Well, thank you very much, sir. We're gonna close
Pleasure.
out today. Oh, which patio do you like the
Oh, shoot.
best?
I was afraid you were.
Gonna ask that question.
Oh, man. They are both excellent, and they looks like they both have roses. My wife loves roses.
Oh,
Okay.
wow, good
Yeah.
deal.
So,
Well,
Gary, so the concept behind the conversation on the patio is, a lot of times when we're sitting on the patios with our friends and our families, and all kinds of topics kind of roll around on a patio, right? And you relax. You're having a drink or iced tea or and sitting around, and so that was the purpose of conversations on the patio, having these real life question conversations in a relaxed environment so that you can be open and honest with one another.
That's a great concept.
Yeah.
you don't have to choose.
You don't
That's
have to
kind of
choose,
a no-win
Gary.
situation. We have to let it be known that I've bought Gary lunch a couple of times, so it could be putting him in a bad spot, especially if he doesn't pick my patio. So I totally understand that, sir.
They're both great.
Thank you,
I would
Gary. It was a pleasure meeting you, and it's been so informative, and I've learned a lot as well. And I'm sure everyone on Facebook and as we market or broadcast the show, they will have learned a lot as well. So we hope they'll run out there and at least sign up and set up an appointment for a free consultation.
Thank you. Well, I enjoyed meeting you. I look forward to meeting you in person at some point in the future and seeing Jevon back at lunch.
I know,
Okay.
huh? Yeah. So I think that's the one thing people are really is like, I just need people contact.
Yeah, I think you're right. All righty.
Yeah.
Well, let's go ahead and close it down. So thank you very much, Gary. We really do appreciate it.
My
Take care
pleasure.
now.
Have a nice
Have a
afternoon.
good one.
Bye
Be
bye.
safe. Bye bye, everyone.